We're here on a motion to enter and dueling motions for reconsideration. Is that correct?
Yes, Your Honor.
That is correct.
If you want me to reconsider something because of new evidence, I guess I could decide whether I'm going to let you do that, and then we need evidence, right?
Great. I have Miss Rothis available to testify at 3 p.m. today, Your Honor, briefly on some of the things that happened during the summer possession and some of the things that have come out during therapeutic work that she's done with the children that I think goes and speaks to the issue on my client's request that Miss Linton have the traditional standard possession schedule instead of the expanded. And then I have Mr. Linton present to testify about the decision of the Travis County Appraisal District, Central Appraisal District's ruling on the rental property Flying J was valued at $980,000, which is considerably less than the amount that was on the spreadsheet by the parties. The parties had agreed to use the TCAD value because we couldn't have the property appraised. It's now made $170,000 adjustment. And so we are asking the court to take that into consideration.
But probably based on a protest that wasn't heard and decided before I had this trial. Yes or no?
That is correct.
I'm not going to do that. Just like when I was in y'all's position, I tried a lawsuit and 6 months later, somebody said, I'm trying to sell it. It didn't sell for that much. Markets changed. It could have gone up 100,000 in 2 months. It could have gone down. Ms. Mccliment, so y'all agreed to use that value. I'm not going to reconsider that because he had a successful protest. Because furthermore, I don't think usually the appraisal district value, y'all agreed to it, is usually not right anyway. It's usually lower, but so does that take care of that?
Yes, if the court's position is that it was the gamble, and I understand, Judge.
If it's new evidence that things that happened after the date of the trial, and y'all agreed, then I'm not gonna. You can't say, King's X behind my back, and if I win this appraisal, protest, I get to lower the value. If I don't remember specifically, but if you're telling me y'all agreed to use what was then the Travis Central Appraisal District value, you're going to live with that.
Right. We were unable to have it appraised. Ted Lear said he couldn't because the property was in litigation. And so he was not able to appraise this particular one. He did the marital residence, but he wasn't able to do Flying J because of that litigation.
No, I understand, but you made an agreement with Mr. Culp. And now you want to change that agreement based on evidence that happened subsequently. And that I don't think is fair, and I'm not going to consider.
Understood. We would like the court to hear from Ms. Rothis, though. Ms. Linton did take the children to California. The children over the summer reported to Dad that they were in Houston the whole time and denied leaving the state of Texas and have made some regressions in the way that they are interacting with Dad. There are concerns that Ms. Linton has instructed the children to not disclose that they were traveling. She also prohibited Mr. Linton from having that phone conversations with the children during that period. He's ordered to have FaceTime once every 48 hours. That was completely denied to Mr. Linton. And so we are asking the court to take that up and consider its position with the expanded standard.
Judge, I'm sorry, can I ask a question? Miss Mccliment, your audio is very low.
I apologize.
Oh, that's so much better.
Sorry about that.
Way better.
Do you want me to restate that, Judge, or were you able to hear me?
I heard you, just so Ms. Mccliment could hear it to make a record. I'm okay.
It's fine. It's fine. Thank you.
Okay. All right. If there's evidence that I'm pulling up my order. Tell me, did I say anything about, calls during visits? Where is that in my letter? Oh, FaceTime with the other parent. Okay. Well, If there's evidence that that part of my order was not complied with, I will take up that new evidence.
Well, Your Honor, if I may, I think what this seems to be then would be more of an enforcement issue, not what is effectively a modification of the possession and access schedule. The court took 4 days of testimony, heard from all of the professionals that were working in this case, I think with the exception of Tao Fan, and made its ruling not conditioned on anything, but that Ms. Linton was going to have an expanded standard possession schedule and was
Well,
going
let
to
me
work.
stop you. You have also filed a motion to reconsider or clarify. You want me to reconsider, or do you want me to set it's? You've asked me to do the same thing, haven't you, Mr. Culp? Yes, it's.
I understand, Your Honor. I'm just, I think the only thing I'm saying is that a fundamental change to the possession schedule, we have some minor changes to the possession schedule that are really, I would characterize more as tweaks. This is more of a fundamental change that they're proposing. But I take your point. I just wanted to make that.
Your point would be a lot stronger had you not filed a motion to ask me to reconsider too. So,
I understand, Judge.
all right. How are we going to proceed? We're going to pull up a draft decree until 3 o'clock. What are we going to do?
Yeah, if I can share my screen, Your Honor, I can start taking the court through our edits. The first, Your Honor, is just on in the conservatorship section. This is on page 3 of our draft. Our request is just that we add right of access to extracurricular activities, just to make clear that so that both parties have access to information about where the kids are attending these activities and things of that nature.
So my response to that would be they're modifying the form language and the Our Family Wizard section, which talks about information that each party is supposed to provide to the other party, includes information about extracurriculars. So Mr. Linton is already required, just like Ms. Linton is required, to share extracurricular information to the other parent. Under those terms, I don't think broadening the rights to include extracurricular is appropriate.
I agree that changing the language from the family code as to rights and duties is inappropriate. It can be dealt with elsewhere, but I'm not going to do it there. So that will be taken out, Mr. Cole.
Understood, Judge.
Why don't you do it as we go? If we're working from this one, why don't you make the edits as we go?
Okay,
Thank you.
no problem. The next change, Your Honor, is on page 7. That is to remove the lifting language. I don't believe that the lifting language is standard. I do believe that's something that either needs to be ordered specifically or otherwise agreed to, and so we've removed that language from the order.
No, I believe that's standard in the family practice manual. Why in the world wouldn't I have the lifting language? If she moves away, why should he be required to stay here? The only reason we have a geographic restriction is to make sure children are around both parents. If she didn't, I can't order her to stay, but if she decides to go, I'm not going to make him stay.
I understand, Your Honor. Thank you.
And I did confirm it is in the practice manual.
I'm aware it is.
Okay.
Understood.
The next is just, we added calendar days.
We agreed to that, Mr.
Okay.
Cole.
All right. Yeah, thank you. This is an issue, I think, that is part of Mr. Linton's motion to reconsider, but the court did not order that the conservators notify each other of travel outside the state of Texas. And I'm not aware of that being part of the family manual or the family practice manual, or it's not the same as a notice for international travel. So we've removed that as well. We would ask that if the court is going to consider evidence or put that in, just that notice be mutual if the court decides to keep it in.
Your Honor, I would agree with Mr. Culp that it is not part of the form manual. The court did not specifically order this. We are asking that it be mutual on both parties, that they notify if the children are going to travel outside the state of Texas, that they notify the other parent to at least disclose date, time, location of where the children are going to be and when the children will be returning to Texas. This has become an issue with Miss Linton leaving and not informing Mr. Linton of where the children are, but then also withholding all types of communication. I think you're going to hear from Ms. Rothis and my client today that again did happen this summer after your order. In June, Miss Linton traveled outside the state, refused to allow communication whatsoever with the children, and refused to um, provide my client with any information for whereabouts. He asked where the children were, and she said that if there was an emergency, she would notify him. That was the extent of her being transparent about the children's
I'm
whereabouts.
gonna hold a ruling on that until I hear the evidence from, about what happened this summer. As an aside, did the kids go to Camp Longhorn or not?
They did.
They did.
Good. Thank you, parents. That was the right thing to do. All right, let's go ahead. We're gonna hold off on that one.
Your Honor, the next is just the issue of the 529 accounts. Ms. Linton testified that her father was the one who initiated all of the 529 accounts that are currently existing for the children, and that I think there was some disagreement during the pendency of the divorce, and this was before I was in the case, but Miss Linton's position is that because the 529 accounts were initiated by her father, that she should be in charge of controlling those. And so we've just flipped it around to where Miss Linton's in control. She'll give Mr. Linton all of the documentation and things of that nature that would be required of her in the reverse. But again, just because it was started on her end of the family, so she's requesting that they basically be maintained here. And then these 529 plans down below, as I understand it from Ms. Linton, are actually still in control of Mr. Albers. So I'm not sure that those actually should be in here. I should probably have those struck through if that's the case. But that's our request on the 529 accounts.
Our response would be is that Mr. Linton seeded those accounts originally. There were contributions made by Ken Albers to those accounts. Mr. Linton, since he does investments and is knowledgeable on finances for a living, that it would be best suited for him to continue managing those. We have concerns that there would not be transparency if Ms. Linton is in control with them, and Mr. Linton is very diligent in sharing information and being transparent. So we are asking that the court to confirm its prior ruling on that issue.
Well, I think we just have some dispute over whether or not Mr. Albers or Mr. Linton was the one that actually initiated and seeded those accounts.
There was a dispute and I heard the evidence and I didn't order that Ms. Linton have those. So I've got conflicting evidence as community, and given conflicting evidence, whether who seeded them, there were community contributions. Even if the father initiated them and there were later community contributions, I'm not going to change my order about that.
Okay. And I'll do another pass on these to make sure that that's done correctly. I just don't want to take up too much time on that, if that's okay with the court.
Sure, thank you.
Our next request, Your Honor, understanding that this is in the family code, I understand the the holiday start and end times. But I think that, so what we've proposed is that where this is applicable, all holiday periods, summer, what have you, basically be school to school rather than ending at 6 p.m. And that's just to avoid any unnecessary exchanges between the parents. Um, I think things will run a lot more smoothly for this family if they don't have to interact that way. And so again, even though I do recognize that it is part of the family code, I think I believe the court's intention was to try to ease some of the tension here, and I think this achieves that better than adding these additional exchanges. So I think that would be the most helpful to the parents.
Your Honor, we're asking that the court follow the practice manual language and the family code language. Mr. Linton is the primary conservator. He is the one that's going to have the children the majority of the school week at his residence, and it allows the children to settle back into his home prior to the school week resuming. That also allows for the transfer of equipment, school stuff to his residence. And so we are asking for that to remain as ordered in the family code.
I'm making a note of what I'm reserving till I hear whatever evidence I'm gonna hear, so we'll hold off on that one too.
Okay. On page 16, we added holidays regardless of geographic distance. That is, I assume that's okay. That's just a clarifier.
That's correct.
Ms.
Okay.
Mccliment is shaking her head yes, so you might as well accept that one.
Okay, thank you. All right, and I'll keep going through, knowing that you're reserving. For the Jewish holidays, Your Honor, I don't think the court gave us specific time guidance on the start and end times. Are these agreed, Mrs. Mccliment?
Yes, they are.
Okay, then I can accept these and move forward. Okay. And while I'm doing that, Your Honor, the next thing was we wanted to see if the court would be willing to allow Miss Linton to have the entirety. Mr. Linton got a plethora of Jewish holidays carved out of Miss Linton's time, and so we wanted to. The court did grant Miss Linton time for the Easter holiday. We would just like that to be a full weekend. And then Miss Linton has some additional requests regarding Shrove Tuesday and Ash Wednesday. And that's just to equalize the Christian holidays versus the Jewish holidays that are the Christian holidays that are important to Miss Linton. And then the final is just that Miss Linton has a family reunion that she's done every year with the children. And we just want to make sure that she has a carve out for that day. It usually falls during the winter break at school, so we just want to make sure it's not even an overnight. It takes place in LaGrange, Texas, so we just want to make sure that she has that preserved. And so those are our requests on that, just to make sure that we kind of have all that balanced out.
Mccliment.
So we're not in an agreement with Easter being expanded to the Thursday before Good Friday through the Tuesday following Easter. That is 5 days of possession. And the problem with that is that the court ordered that Mr. Linton have Passover. And based on my review, just for the next, for example, this year, Good Friday overlapped with Passover. And then in 2029, Good Friday overlaps and Easter overlaps with Passover. And so there's just some conflicts that will happen if we do this broad block period of possession for Miss Linton. Easter Sunday doesn't appear to actually itself overlap, but Good Friday seems to be the conflict. So we would ask the court to keep its original ruling. And in addition, Shrove Tuesday, so that's usually, we kind of refer to it as Fat Tuesday, and Ash Wednesday, those are back to back. And so I guess my question is, I know that there is one, and Mr. Linton can probably speak to this, that sometimes can conflict with one of the Jewish holidays. And so to the extent that it's trying to override one of his Jewish holidays that have already been awarded to him, we would have an objection there.
I don't need to hear it. That's way too complicated. I'm not changing my ruling. Other than she can have Easter as I set out.
Understood.
Would the court consider just two additional days that we could select around those times that would not conflict?
Nope.
Okay.
This is not about keeping track. I limited his to 24-hour periods. The children had been raised Jewish before this happened. Nope. I'm not doing it.
Okay.
I think you meant 3 p.m. because I think you were doing 3 p.m. on everything else.
So, thank you very much.
Sir.
Okay. I think we were just missing the word possession here. So I'm
All
assuming
of those are
all of
perfectly
these-
fine.
That's what I thought. Okay. Here, Your Honor, on page 21, we removed the language about this particular injunction being on everybody's the agency language. Essentially, the way that read to me as written was that this would be an injunction on any extended family members also being present during extracurricular activities, or that one parent could be subject to being like if Miss Linton's parents wanted to attend, or her father, excuse me, wanted to attend an extracurricular activity, what this could create is a scenario where even if he did that on his own volition, even if he did it against Miss Linton's wishes, that Miss Linton could get in trouble for that, because it could be, we could understand that there could be a misunderstanding that Mr. Albers was acting at her request. And there's no prohibition on the grandparents. I don't think the court can prohibit the grandparents from doing anything. I understand the court's ruling on everything else. But so we remove that agency language so that I don't want there to be that conflict, and I don't think it's applicable.
I don't have an objection to the agency language being struck because I read it the way that Mr. Culp does as well. However, we do have an objection to the modification of the injunction language itself.
Are you talking about where the children are present?
Right, like I think that the way I wrote it, attending any of the children's extracurriculars, I think that is important with the language, because I think that your client would read it, if it's not an extracurricular of all of the children, that then she's exempt from it. That's why I wanted to be specific that if any one of the children is in an extracurricular, that they are restricted from attending.
Okay. I mean, I think it's clear attending the children's extracurricular. I mean, we define the children broadly throughout the entire order.
I like Miss Mccliment's because we had so many problems getting this case to trial. So this may be one where we're going to be a little more specific. It's my recollection of the evidence.
Okay. this language here, though, because we have the phrase school programs, I think school programs could be very broadly defined as a parent-teacher conference or an open house where the children aren't necessarily present. And I don't want this to work as a prohibition on parents attending school functions. I think the idea is to keep the parents separated while the children are present so as not to interfere.
Mr. Culp, we're fine with that inclusion.
Oh, I'm sorry. I thought you had objected to it. Excuse me.
Sorry, any of the children, but we're fine with what you're requesting.
Understood. Thank you. The next, Your Honor, is on, I don't believe the court made specific findings that Miss Linton was underemploying herself. And so we removed that language. The court's ruling is that Miss Linton, based on her education, experience, et cetera, was capable of earning $40,000 a year, but not explicitly that she was underemploying herself. So we've removed that language as it appeared. I think it appeared twice here. 3 times, excuse me.
I didn't make an intentional unemployment. I think that was just a specific reason I said she's capable.
Okay.
Since she wasn't, based on the evidence and the things she had done. I mean, I understand Mr. Linton thinks, and she probably can make more money, and if that happens, I guess he can come back for modification. But I'm not gonna leave that, I'm not gonna have underemployed language in there.
Thank
I
you.
was just concerned for appellate purposes if it didn't have a finding that since she testified she's only making X amount now, that if there wasn't a specific finding of underemployment, that would be something that would be brought up. And that is why I included that, since the education and past work experience would meet the criteria for a finding of underemployment. And so that was the only reason that I felt it was appropriate to have that specifically in the
I
order.
understand, and I think if I had been specifically asked, maybe I would have done it, but I don't think I was asked to do that, so I'm not gonna include it now.
Okay. Just for the record, Your Honor, I did in our PDI and in our pleadings have a request that the court find that she was underemploying. But if the court's declining that, I understand the court's position.
I'm declining that. Thank you.
Your Honor, the next is the court had ordered Ms. Linton's child support start date of September 1st, which is in 6 days. As it stands right now, we don't have a decree entered, so I understand that a lot of the things that Mr. Linton is going to have to do in order to be able to get Miss Linton the cash out of the estate that she needs is likely going to need to be postponed until we can get a decree entered. But Miss Linton has been trying to find work. Thus far, the only work that she's been able to find, as I understand it, is as a substitute teacher at a Montessori school. She's also been ordered to pay. I mean, she's lost her child support that she was receiving from Mr. Linton. The court has also required that she pay Miss Haney and Summer Allen once that takes back over, as well as Miss Nixon and half of Tao Fan. So this all this is all part of a thing that we're asking the court to reconsider, is to allow Miss Linton additional time before she starts paying child support, at least until she can get some money out of the estate so that she could support herself and her rent and bills that are currently due. I have more on this, but this is kind of the beginning of that request. There's a very large income disparity between these two folks. Mr. Linton makes, at time of trial, testified at least $30,000 a month. So we're not asking the court to say no child support, just that we have a little bit more time before that starts.
Wyman.
Our response would be that if the court grants Mr. Linton's request to extend out his deadline of when he has to make that first $200,000 payment to Miss Linton, that her child support obligations start the first day of the month after his first lump sum equalization payment is made to her. He's not trying to put Miss Linton in a position where she's not able to pay her child support knowing that she has been out of the workforce for some time. We have pled for and asked that the court extend his deadline to pay till 90 days after the decree is entered. But my client, I think, will explain to the court, he's very hopeful that it will only be 30 days. He has found somebody who is a potential buyer for Flying J, or at least a portion of Flying J. So they have requested that their attorney have the final decree of divorce so that they can review it, confirm that the deed has been transferred from Miss Linton to Mr. Linton. So we would need it at least 30 days, but we have requested 90 to be safe. But if it's 30 days, then we would ask that Miss Linton's child support payment begin October 1st. Because right now, the way that the letter ruling was issued, he would have to pay Miss Linton by August 31st in 6 days, and that there's no possibility that that can happen without having the deeds executed and the decree entered.
And I think we would be fine with that, Your Honor, going to the month following the time that at least the initial 200,000 that Mr. Linton owes would be paid.
Well, I appreciate that. There was a reason I asked y'all to set this beginning in the first week of July. Now I realize I've just been gone for 2 weeks, but there's a reason I wanted to have a hearing set if y'all hadn't agreed to the form of the order by July 10th. Why don't we give him 60 days and have her child support start October 1st? That gives him 60 days.
Okay. Can I go back through and make that change? Because I think there's going to be a couple of things we're going to need to move around.
Yes.
Okay, thank you. Okay. Our next request, Your Honor, is on page 30. Oops. Okay, just to be clear for the record, same applies to health insurance, dental insurance, all of that, correct, Your Honor? The October 1st? Then our next request, Your Honor, is on page 33. There was some additional language that Mr. Linton added about the scope of Lara Nixon's appointment. I think the court had a relatively narrow scope in the letter ruling. And so the addition of summer camp and extracurricular activities, specifically, it being somewhat one-sided, whether or not Miss Linton has the ability to make extracurricular activity changes without the approval of Mr. Linton. The court didn't order that specifically for Miss Nixon. I imagine that's something that she might be able to help them with if they bring that to her. But didn't want to be bound by that. And then they also included language that basically allowing Miss Nixon right now to have a money judgment for any amount unpaid. That also wasn't in the letter ruling, and we would I think that would be between Miss Nixon and whichever party is in debt to her for that. So those are the reasons for those two changes there, Your Honor.
So the court in subsection 1A states that Ms. Nixon is to assist the parties in resolving disputes about the children's extracurricular activities. We were trying to give an example because there's already been issues surrounding extracurricular activity enrollment. But if the court doesn't want to expand upon that, then I think that Mr. Culp's red line edit would then be appropriate.
I mean, I think his edit is exactly the kind of thing I want Miss Nixon to help them with. And if they can't agree and somebody has to come back to court, me or whoever else hears this, I want to hear from Miss Nixon about how the parties cooperated in resolving a dispute or what their positions were. So,
Excuse me.
Go ahead.
So with that said, so with the court reserving the right to order a reasonable fee, Miss Linton's refused to sign the paperwork with Miss Nixon and move forward with utilizing her. And so we did want, since she's not even under contract and she's attempting to work with the parties pursuant to the court's order, we would like the court to reserve the right to order reasonable fees if Miss Linton refuses to sign any engagement
No,
agreements.
here's what I would say to you is, if that's true, this decree is signed and Miss Linton, surely she won't. If she refuses to sign the documents with Miss Nixon and to engage with Miss Nixon, that would certainly be something a court would consider in any future modifications, including limiting Miss Linton more than she's already been limited. So I'm not going to include a money judgment, because if Miss Linton refuses to engage with Miss Nixon, she refuses to engage. I would say, and I hope she hears me, it's to her detriment. Things will only get worse.
And to
Because
be
I can sure look at that and go, I tried to give you somebody to talk to about this. And if you refuse to play, if you refuse to utilize those people, and there's a problem, it's going to be clear to me, I would think, largely why there's a problem. That means somebody doesn't want to cooperate and work with somebody to work it out. So I'm not going to say she can get a money judgment, because if Miss Linton doesn't sign the paperwork and doesn't cooperate, then maybe somebody's going to come back and we'll let Miss Nixon go, and I'll check, the rights and powers will be changed, and the way we do extracurriculars will be changed if she refuses to cooperate.
Understood.
And to be clear, Your Honor, this is not Miss Linton. I mean, this is not Miss Linton refusing to work with Miss Nixon. I think Miss Linton's position has just been, as I understand it, I can't afford to pay the retainer just yet. I think they even have made an appointment to speak with each other over the weekend. If they didn't this past weekend, I need to double check that. But if the court is inclined to add the language that I deleted with regard to the scope, what I would say then is to change to make it not one-sided against Miss Linton. Then it's whether or not either parent can make unilateral extracurricular activity changes, and whether either parent can enroll in summer camp and things of that nature, so that it's balanced, and not just, that way the scope is as broad as it can be, while also being inclusive and achieving what the court is trying to achieve with having Miss Nixon appointed.
That modification.
I'm sorry,
I said, Ms. Mccliment, do you agree with that modification suggested by Mr. Cole?
No, because Mr. Linton has enrolled the children in extracurriculars that they've requested to be enrolled in, since he has the children the majority of the time during the school year. So that would really limit him in being able to make any progress, because I think the evidence you're going to see is that Miss Linton takes 2 to 3 weeks to respond on OFW since the court's ruling, and it's going to be very difficult to move any of these forward to meet deadlines for enrolling children in extracurriculars.
I know, I believe what a reasonable person and what Miss Nixon would say, which is if he enrolls them and it's mostly on his time, he can do it. I don't want him enrolling in children he shouldn't on a time that is during her midweek possession. But quite frankly, it seems I'm more worried about, well,
it just, again, I think it should work both ways. If right now, if the kids are enrolled in extracurricular activities, either parent should be able to unilaterally unenroll them.
Their parent should be able to unilaterally unenroll them? No.
Oh, no, I'm sorry. I did not, if that's what I said, that is certainly not what I meant. No parent should be able to unilaterally unenroll a child from an extracurricular activity. That's my point. What I'm saying is that's fine. Neither parent should be able to do that. The way that they have it drafted suggests that that's what's happening, and it's not. What I'm saying is that the language should say Miss Nixon is going to talk to both parents about whether either one of them can unenroll or enroll in extracurriculars or summer camp or what have you, so that it's on both.
Mr. Kolb, I would agree to just that, for example, why don't we just strike that whole sentence? So we're leaving that she's going to be addressing summer camp and the time and when summer camp falls, but then we'll just strike the example where your client is being highlighted. And then I think it's already very clear based on what the court has discussed with us this afternoon that
I think it's clear. I agree with that, and I think Ms. Nixon will understand exactly what the court means. She's had this kind of rodeo more than once.
I agree. And
Agreed.
so it would look like that, correct? Okay. This, Ms. Mccliment, I think we've agreed, or is okay? Is that
No,
fine?
because your client's going to say that she just had to write the letter and give it to Lisa Rothis and that she's no longer needing to work with Miss Haney. So
Well, I
that's
think I'm sorry, I didn't mean to interrupt.
so I don't think that Miss Haney has discharged your client, and that's why I don't like the modification or agree to it.
Right. Well, I think Your Honor, I think this still allows for Miss Haney to release Miss Linton.
I think it does too without the addition. It's already defined and in progress. I don't think you need that language.
Well, I guess, I think with Miss Haney, I think our issue, just to explain it, Your Honor, is that I think Miss Haney had a very specific purpose as it related to the goings on during the divorce and things of that nature. And then the idea is for Summer Allen to take over after that. And so without a clear scope of what Miss Haney is supposed to do, which I think should be somewhat limited, that period can go on indefinitely. So
I think, given what I have seen, Miss Haney's going to read the second paragraph about Summer Allen. So I'm not worried about that. Let's take out as already defined and in progress.
the next change, again, Your Honor, it goes back to cost. We are asking that Miss Linton be allowed to use a therapist that Miss Allen, either Miss Allen, Dr. Allen, excuse me, or a designee of Dr. Allen who might take Miss Linton, who would take Miss Linton's health insurance. Because I think that the cost of Summer Allen, and if Dr. Allen is wanting to see Miss Linton weekly, which we don't even know yet, could be hundreds of dollars a month. That would be very difficult for her to be able to afford. So, if Dr. Allen knows somebody who she would have faith in could handle this case, who would take insurance, that would be our request.
Our response is that Dr. Ainsley was very careful in making this recommendation because she wanted Miss Linton to have that DBT, individual and group therapy, through Dr. Allen's practice. And so I don't know if Dr. Allen's practice accepts insurance. I don't think that it does, but this was what was recommended by the court-appointed child custody evaluator. And we would ask that it remain as ordered without an designee option. And also, Mr. Culp's spreadsheet that he circulated to me earlier in preparation of this hearing evidence that Miss Linton's been awarded over $1 million worth of assets in the division of this estate. She's going to have $400,000 of liquid capital available to her within the next 6 months, 60 days, and she's having $200,000. So I think that she's going to be able to pay for Dr. Allen's services.
I'm not gonna, I specifically wanted Dr. Allen for all the reasons that Ms. Mccliment said. And this is as difficult a case as I had seen in a long time. And it's my belief that if I put things like that in there, it's just gonna continue to be problematic going forward. So let's be clear, Dr. Allen.
Well, Your Honor, is there a way that we could put some sort of financial fail-safe in? I think.
Nope. I wish, you know what, respectfully, Mr. Culp and Ms. Linton, what do I remember? Was it $1 million in fees we spent, 4 or 5 lawyers? I wish somebody had thought about that before we went through all of this. This was predictable, what was going to happen the way this case was litigated, or as long as it was litigated. So sorry, no.
Understood, Your Honor.
if there had been any recognition about what we were doing to the estate and how this case went, you would have gotten further, but not until it was all over. Now are we worried about things?
This next change is just that the letter ruling was that Mr. Linton continued to work with Dr. Thomas Parker, not Mary Alvarez, so I just made that change.
So Dr. Parker has not worked with Mr. Linton. That was a recommendation of Dr. Ainsley. However, my client has reached out to Dr. Parker, and Dr. Parker has stated that he is no longer accepting new patients. And that is our issue, is that my client's happy to do what the court would like. Dr. Alvarez has stated that she is willing to work with Mr. Linton in addressing co-parenting and issues since
Here's
she
what we're
was.
gonna do. Dr. Parker was who was recommended, who is in my letter, or if he is, you
Correct.
can say if he is not or if Dr. Parker is unwilling or unavailable, not taking new clients by whoever Dr. Parker recommends.
Thank you, Your Honor. And since we have Lisa Rothis in the waiting room, is it possible, Your Honor, for us to hear from her so that we're not having to pay for her hourly rate while she sits there?
Sure, I had wondered when somebody was going to bring that up. Let Mr. Culp finish this one change, and then we'll come back to that. Mr. Culp, remember what page we're on, please.
34, yes, Your Honor. That look okay, Ms. Mccliment?
Correct, yes.
Okay. Let me stop sharing my screen.
Stop your search. All right. See if I can let her in. All right, there's Miss Rose. Hi, Ms. Rothfuss. Would you please raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
Would you state your full name for the record?
Lisa Rothfuss, spelled R-O, T like in Tom, H like in hat, F like in Frank, U-S like in Sam.
And Ms. Rothis, can you remind the court how you're involved with the Linton children?
Yes, I have been working with them as a reunification therapist, family therapy, since March of 2024.
And after the final trial in this divorce matter, did you continue to treat the children?
I have seen them several times.
Okay. When was the last time you saw the children?
Last week on 8/18/2025.
And who brought the children to that session?
Dad did.
Okay. Did Mr. Linton participate at all in that session?
Yes.
How would you describe the children's interactions with Mr. Linton during that session?
Very quiet, very withholding. They when we talked about certain issues, they were very quiet and withholding. Other than that, they also seemed like, they were happy to be with Dad.
Prior to the final trial in this matter, how would you describe the interactions with the children and their father during sessions?
Prior to the trial?
Correct. Like immediately prior to.
Immediately prior to. Well, they were doing okay with Dad. I mean, everybody was getting along pretty well. Before the trial, I think there have been a lot of changes for the children, so they were, trying to deal with a lot of different change that was happening.
When you were testifying at a temporary order hearing in front of Judge De La Yata after the reunification work had been done, would you agree that your testimony was that the children and their father's relationship had been repaired?
Yes,
Okay. Do you have any concerns about the repair work that had been done based on your current interactions or more recent interactions with the children and Mr. Linton?
yes.
And why do you have concerns?
Well, Mr. Linton called me and asked me to do a session with the children because he had found out during the time that they were with Mrs. Linton on her possession time, they had actually taken a trip to
I'm gonna
California.
object to hearsay or well, potentially hearsay. Um, there's no foundation for Mr. Linton's personal knowledge about anything that I think anything that Ms. Roth is about to describe right now.
Well, if Ms. Rothis has personal knowledge of what the children said in a session where she's
Miss
treating,
Ms. Rothfuss is limited to what the children might have said. I don't want her testimony to be based on what father told her, which may or may not be based on hearsay.
Ms. Rothis, let me ask you a question. Did the children tell you whether or not they went on any trips this summer?
They said that they had gone to Houston and they did say that they had gone to California.
Did they discuss in front of you or with Mr. Linton in the session their truthfulness to their father about going to California?
Yes,
And what did they state to you?
they said that
Well, I guess I'm gonna have to object. How I don't understand how those statements need to be linked to a specific treatment of the children. That it has to be, it's not whether or not they were being truthful with their father, but whether or not they are, whether or not that impacts or how that affects their understanding of what they're being treated for.
Well,
It's not it's not just any statement that's made in therapy can be repeated. It has to be specific to the treatment.
so she mentioned that there was a regression in the interactions and relationship between the children and the father from where they were after
That
the reunion.
objection right now is overruled. Go ahead.
Okay, Ms. Rothos, you can answer the question,
can you repeat the question?
right? What did the children state in front of you regarding their truthfulness to their father about the trip to California?
They said that he had not asked them directly if they had gone to California. They had only asked him, he had only asked them about what they did during the time they were with mom. And so they did not, because he didn't ask them directly whether they'd gone to California, they did not say they had gone to California.
Did the children express any concerns about what would happen if they did tell their father that they were in California?
Leah felt like her dad would make her come home early from California.
Did you discuss that with Leah and Mr. Linton in the session?
Yes, we did.
Okay. And were there any other concerns that you had about why they weren't telling, or did the kids explain to you why they weren't telling their father information about what they were doing this summer?
Leah just said that she was afraid that dad would make them come home early from their trip with mom. And so she hadn't wanted to say anything. And Matthew had said that they had been in places where they actually talked to dad. They didn't have cell coverage.
When the children were in California, was Leah baptized?
Leah says she was baptized, yes.
And did Mr. Linton attempt to talk to Leah about that in the session with you?
Yes.
And did Mr. Linton get told, to your knowledge at all, that the child was being baptized?
Objection leading.
You know what? Why is that relevant? They each have the right, to direct the moral and religious training of the child.
I agree. It's about what the child shared, Your Honor, with it as to why she couldn't disclose or didn't want to disclose it to her father. So I'll keep it really brief if I can just ask that question. May I ask that question, Your Honor?
Go ahead.
Ms. Rothis, what did Leah state about why she didn't tell her father that she was being baptized?
She just said that she didn't feel comfortable talking to him about any of that.
prior to the summer possession, was Leah willing to have conversations in session with her dad about various disputes?
Yes.
Okay. And were there any other conflicts that you helped work through with the children and their father in this last session?
There were some issues around communication, that, the children had been upset about when dad went to retrieve their belongings at summer camp. They were angry at him for being there. And we did talk a little bit about that. Dad, did discuss that with them.
Did you have any concerns about the type of information that the children had learned about disagreements between the parents over the summer?
I think that the concern was that the children oftentimes got stuck in the middle, like they didn't really know what was happening. And therefore, they often felt frustrated or angry with dad. They felt like he was maybe, intruding on their space or their time with mom.
Nothing further, Your Honor. I'm going to pass the witness.
Mr. Culp.
Yeah, Ms. Rothfuss, you said that the children are still appear to be happy to be around their father. Is that right?
Yeah, they were sitting by him on the couch and kind of they goof around a little bit when they're in the office together.
Okay. And children being, the kids presumably are talking to dad and talking to you in sessions about things that are kind of difficult to talk about, right?
Sometimes, yes.
Okay. And sometimes that can be difficult for kids, and that difficulty may manifest itself in different ways, right? Being a little withholding, maybe being frustrated, maybe being even angry sometimes, right?
Good. Yeah.
And you have to help them work through that, right?
Yes.
Okay. And it sounded to me like what the kids were doing was that maybe the children were not being truthful with their father, correct?
It did sound like that, yes.
And that's definitely something that you could work with the children on, like, hey, listen, if your dad asks you a direct question, then you need to be honest and forthcoming about the answer. That's your job as a child, right? To tell your parents the truth, correct?
Yes, we talked about that.
Okay. And you did not testify that that Miss Linton was telling the children to not disclose this information to their father. Is that right?
I did not testify to that.
All right. And so were you aware of, so the issue with the clothing at summer camp, is it your understanding is it your understanding that Miss Linton was really the driver behind Camp Longhorn this past summer, right?
I don't know.
Okay, all right. And it was Miss Linton who picked up the children from summer camp.
Yes, is my understanding she picked them up.
Okay, and that Mr. Linton showed up on the same day and took all of the children's clothing with him in their luggage, even though Miss Linton was taking the children back to her home after camp. Were you aware of that?
That's what was reported to me, yes.
Okay. So it could be that the kids were frustrated with dad because maybe they weren't expecting him to show up and take their clothing, right?
Could be, yes.
Okay. And that can contribute to them kind of feeling like they're in the middle of things, right? They don't know if we're going with mom, why are our clothes going with dad? Maybe why is dad even here? Things like that, right?
Sure, yes.
Things that could have been communicated by Mr. Linton to the children. I'm not sure if they were or not, but that's something that could have been, and those are things that you could have addressed and can address with Mr. Linton and the children together, correct?
Yes.
And you haven't listened to any audio recordings or video recordings since trial?
No.
Of the family? Okay. And obviously you haven't sat in the home with Mr. Linton and the children or anything like that. Your contact has been limited to sessions.
Correct.
You haven't spoken to Miss Linton about any of these issues, correct?
No.
Pass the witness.
Ms. Rothfuss, were you aware that Miss Linton's possession for the summer was on the same day that the Camp Longhorn program ended? That it started the same day that the camp was ending?
Yes.
Okay. And Were you did you specifically ask the children if they talked to their dad while they were on the trip in California?
The children told me they did not talk to their dad while they were on their trip to California.
What did they specifically say when you asked that question, if you recall?
Matthew said they were in places where there was no cell phone coverage, that they couldn't speak to him. Joshua didn't respond. Leah didn't really comment.
How would you describe the children's demeanor when you were having that conversation with them?
They seemed shut down, very guarded. Just like they weren't sure they wanted to say very much.
Okay. How would you describe Leah's affect when you approached the California topic?
She seemed very hesitant to speak about it or say very much of anything about it, but also worried that dad would have made her come home early.
Okay. Nothing further. I'll pass the witness.
Nothing further, Your Honor.
May this witness be excused.
Yes, Your Honor.
Yes.
Thank you, Ms. Rothfuss.
Thank you.
All right, are we going to go back to the decree and then we'll come back to, or we did
Yes.
that, or we call it? Given I
Whatever you
heard from her, let's do that. And then given I heard from Ms. Rothfuss, I'll hear briefly from each party if you all think that's helpful for the other decisions I need to make.
Agreed. That sounds fine, Your Honor.
And I'm sorry, Judge. So are we continuing through the decree? Or are we?
Yes, please.
Okay. My apologies. I just want to make sure I was clear. Our next request, Your Honor, is just simply that, again, it's economic. We're in agreement for Miss Fan to continue working with the children. We would just ask that Mr. Linton pay the 100% of the cost. You know, again, there's a massive income disparity here, and again, Miss Linton is going to be struggling to keep up with all of these therapeutic appointments. I mean, we're looking at, we could be getting towards $1,000 or more a month in expenses, and the income that the court attributed to her was only $40,000 a year based on her experience and time out of the workforce. So our concern is just that it is not going to not only be practical, but possible for Miss Linton to be able to fulfill these financial obligations, not only her own, but the ones that are ordered by the court, without running afoul of some enforcement action that would even then be impossible for her to cure. So I think we just need a little bit of, if the court would be willing, a little bit of latitude on the finances on these issues.
Our response to that would be that Miss Linton is being awarded over $1 million worth of assets. $1 million, as the court indicated, was spent on attorneys fees litigating this case. It's necessary for Miss Fan to be involved in this because of the actions of Miss Linton as it relates to the children. And so we would ask that the parties share in that expense 50-50.
Request is denied, Mr. Culp. Going to stay 50-50.
Understood, Your Honor. On these financial requests, Your Honor, I also would just say that at least half or a solid chunk of what the court awarded to Miss Linton is retirement that she would have to incur significant tax penalties in order to appreciate the benefit of immediately.
One would hope that people would work hard on their therapy and some of these issues would dissipate especially if the financial strain is too great. That's all I'm going to say about that.
Understood.
I will say, I think I tried to cut Miss Linton a break by saying that she could make $40,000 a year now, because I think she probably can make more money than that.
On the child support side, I understand, Your Honor. One issue the other issue that we just that needs to be addressed is the We Got Catch Up Trust. The spreadsheet that the court adopted stated that trust was to be dissolved, and I think lost my cursor. Their language it didn't quite seem that it was dissolving that asset, but that was what their spreadsheet said, and that was what the court adopted.
I'm fine with that. I just need 30 days because I need the trust attorney to draft all of those
Yeah, but 3
documents.
days to undo a trust is probably a little much. Let's, why don't we change it to 30 days?
Thank you, Your Honor.
Okay. This was an issue of, I will state, I'm not sure if we talked about the piano in trial. Mr. Linton gave Miss Linton a piano as a gift during the course of their marriage. She would simply like to have that piano awarded to her as her separate property. So I have it here and in one other spot below. But that's our very simple request.
I apologize, Your Honor. I received these edits this morning and my client was teaching this morning when I received them. And this is the one topic I did not have a chance to speak to Mr. Linton about. So I don't know the answer to that.
I'm gonna, if this morning was the first time she heard of it, I'm gonna give her a chance to talk to her client about it. But I don't remember anything coming up about the piano.
Well, in our motion, Your Honor, I'm sorry.
I will say this, if it was in fact a gift, Mr. Linton, it would probably, she wants the piano. Well, now you're asking me to do all sorts of things that weren't discussed, so let's move on. Let y'all talk about that.
Thank you, Your Honor. The next issue, this will affect the property division. There was a tax issue. Mr. Linton received credit in his spreadsheet for a roughly $83,000 tax bill for 2024. And in our spreadsheet, Your Honor, Ms. Linton also put an $18,000 credit in. We have that precise number now. It's $17,390, and that swings the overall division of the estate by just over $10,000. So again, I think it just it was in our proposed disposition of issues, just like it was in theirs, and it just didn't. Miss Linton's wasn't acknowledged in the letter ruling or in the spreadsheet, excuse me. So
was it for the same years that they filed separate tax returns?
Yes, both parties for 2024, and that we also have that issue coming up. Both parties in 23 and 24 filed separate, filed separate, married separate. But again, like I said, so Mr. Linton's for 2024 shows a balance due of 83,000. Miss Linton showed 18.
So I thought you had said in your motion that it was 2023 because it looks like, I'm sorry, I'm looking at your motion. It says that in the spreadsheet you sent me earlier, it had cited 2023 as being the year that she had that $18,000 tax liability, because I went and pulled her tax return that she provided to us in discovery, and I've marked that in the box. It's marked as exhibit, I believe it's 8. I'm sorry, it's 9. Petitioner's 9 is Laura Linton's 2023 tax return, which showed that she received a refund of $620. And so I don't know where this number is coming from. And so we can't agree to that.
Give me just 1 second, Ms. Mccliment. Our spreadsheet that we submitted.
I guess my response would be is, Your Honor, there was no evidence presented at the trial by Miss Linton on this. Otherwise, I would have cross-examined her on her 2023 tax return that she did produce, which shows she received a refund. And so it would be our position is that the court didn't acknowledge her tax liability because she didn't put on evidence that there was one where Mr. Linton, we did put on evidence about the 83,000, and he had to receive that because he had to liquidate assets in order to give $250,000, actually more than that, in interim attorney's fees to Miss Linton during the pendency of this case. And so I think that we established why he had that tax liability and why it had to be taken into consideration in the division. But also, I think that the court found that there was grounds for a disproportionate award in this case. And so we're asking the court to deny this because they didn't present any evidence on this issue at trial.
And for clarification, it is 2024. It was in our proposed disposition of issues. I know I walked Ms. Linton through her proposed disposition of issues during trial. And he may be awarded a disproportionate share. That's fine, but the credit that he received that would still factor in, and it would factor in disproportionately the way that it's been awarded. Our motion for today also asks the court to reconsider assets that have not been divided, i.e. the piano and the tax issue here. But again, we submitted our proposed disposition of issues to the court for its consideration twice.
It says Exhibit B, which isn't attached. Let me see if I can find it in my file. Let me see if I can find it. Somebody printed it out for me, but I don't have all the pages.
And it was our second amended proposed disposition of issues, I think, that we filed on May 21st, Your Honor.
Right. So the one filed on May 18th does not have that on there.
There is one filed on the 21st of May. So I'm just pulling that up. And there is a tax liability for 2024 shown on his proposed disposition of issues. It says 18,000, but you're telling me now that that is not the correct amount?
It's $17,390.
We received no discovery to show that amount, how that was.
Okay. Has she got a tax return that shows that amount, Mr. Culp?
For 2024, not yet, Your Honor. I think we're in communication she's in communication with her CPA for 2024. But that.
And I'm gonna, if you had a tax return and you can show it first, it was 18 now. I mean, if you got something to show me, I might be inclined. But just coming up with a number when there's nothing been provided to Ms. Mccliment, I'm not going to. If you have something that shows that amount and why it happened, that's one thing. Do you have any exhibit that would show where that came from?
I don't have it as an exhibit at the moment, Your Honor. I could get an email from her CPA and create an exhibit very quickly.
Get something from her CPA, send it to Ms. Mccliment. Ms. Mccliment, if it's legit and she's got to pay it, I put what he had to pay in taxes. She was working. I mean, it seems fair, although albeit a little late as much of this was. So I'll give you a day or so to see if y'all can agree on that. And if not, I'll make a ruling. What's next?
Thank you, Your Honor. The next is on page 42. We just kind of cleaned up the language a little bit or changed the language to on when Mr. Linton is to sell the property and to pay Miss Linton the cash that she needs to get out of that property, as well as the modification that we're requesting from the court's ruling is that if Mr. Linton is unable to come up with the cash available to come up with the cash, the court's ruling was that he have his choice between selling the two properties. We just asked that it be the Scenic Bluff residence. And the reason for that is that there was testimony at trial, there's been discussion of it here today, that the Flying J residence is currently, as far as I understand it, tied up in litigation and can be tied up in litigation for quite a while, which can impact its ability to be sold at any time. And so the second half of Miss Linton's cash distribution that she's awaiting could be also tied up in that litigation for who knows how long. So that's what we're asking for, is just that, and in addition to that, that there be date certain about when he is to put the house on the market, which we've included, and then just a little bit about that he has to accept any offer within 1% of sale, just so that it's not, we don't have that problem of him sitting and waiting for the best offer when he's got that obligation that he needs to fulfill. So that's the tenor of the changes that we've got there.
So I'm fine with the changes that are in the paragraph going before subpart A, Mr. Culp. So we're fine with the judgment amount of the 406 because that's what the court ordered.
I'll need to tweak that if we have the tax issue, but yes, okay.
And then the court's already ruled that it wouldn't be August 31st, it'll be October 31st. So with that change, then that subpart A is fine. Subpart B, Your Honor, is it possible, since you're giving 60 days for the first payment, that the second payment also be extended 60 days so that it would be instead of instead of November 29th, that it would be due January 29th of 2026?
He has other assets. I think he can borrow it. No, I'm not gonna. No. I mean, I said 6 months again. We should have had this entered last month. So the fact that it's not and it's put everybody behind the 8 ball is, sorry.
So November 29 remains the same, Your Honor?
Yep.
Okay. I think you also, this just reminded me, Your Honor, I apologize. I think you said earlier that her child support obligation would start 60 days after, which I think the court said on the record October 1st. That should be, November 1st would be 60 days out.
Yeah, it should have been November 1st, not October. If I'm giving him an extra 60 days to get the first payment.
Okay. Thank you, Judge. Just wanted to make sure that we had that.
And then Mr. Culp, wait.
Yeah, I'm sorry.
I'm fine with the judgment sentence.
Okay.
And then if we can marry up that following paragraph with the dates that Judge Mossie's already stated, and then you've already made modifications on the amount, but it needs to be based on what judge decides to do as it relates to that tax issue.
That's right.
And then if it needs to be or Flying J, because he is in the process of trying to sell.
I am not going to order that he has to sell the family residence. I gave him the option. I think he can come up with it one way or the other, Flying J or some other way. I feel confident. I'm not going to change my order that it has to be Scenic Bluff be sold. That's not going to happen.
Okay. I will highlight that to modify. The next is on page 43, Your Honor. This relates to the RSUs that were awarded to Miss Linton, and basically, I think the way that they have it listed is that when Miss Linton has to pay taxes on the funds from the RSUs, that she pay it at Mr. Linton's tax bracket. I think that should be that she pays it on her own tax bracket.
No, here's the way that has to go. If the income can be attributed to her, so she pays it on her tax bracket, that's fine. I think it depends on what you do with the RSUs. If that can't happen because the company makes him sell it and he's going to get taxed for it, I'm not, and his tax rate is higher than hers, I'm not going to make him pay the difference.
I'm not trying to get him to pay the difference, Judge. I just want to make sure that if she is ordered to pay, or excuse me, when she is taxed, that she is not taxed against his bracket, just only hers. Not that I'm not trying to get her to split him to split the difference. I'm just saying that it should be that the income should only be attributed to her annual income, not Mr. Linton's, which is
It
5.
has to be attributable to his, because the company's policy as it relates to those RSUs is going to require that he sell them. He is going to get the tax documents, and it's going to be associated with him. And so he's going to have to require that she pay the taxes based on his level. Otherwise, it's going to create a quagmire where he's going to be on the hook for the difference between those two tax brackets. So then he's paying out of pocket for the difference between her tax rate and his tax rate.
As I understand it, that's if the IRS attributes that to his income.
It's going to. It's attached to his social, and he has to sell.
Okay, hold on. I don't know the answer to that. I've told you what I think. Y'all either get on the hook, both of you, with the company or an accountant. I think Miss Mccliment may be right. If the company won't change it and it's attached to his social, I think it gets taxed. Now, if there's a, what is it called, a nominee statement? If there's something the accountant tells you, you can do that so that it's taxed at a lower, I'm fine with that. If there's a way to pay less tax based on her income, I'm fine with that.
Can we write just a simple sentence?
I don't think either of you all know the answer until somebody talks to an accountant and or the company.
If we could add a sentence that states that if there is a way to make that election and that a statement can be provided so that the IRS will recognize that, then I think we preserve it if we keep it this way and we give the alternative that if there's that option, then we've covered all of our bases.
That's how I recall the language I recall using about these kind of things, but it's been several years ago. I would encourage somebody to talk to a CPA about that and make sure that whatever verbiage you put in there covers those options. Because I do think there's sometimes you can do a nominee. I don't know what the form is, the IRS form, so that income isn't attributed to him at his rate, but to her. But
Right.
I'm dangerous. I know just enough to be dangerous and to tell y'all to go look it up. I don't know specifically what's going to happen.
Understood.
The other issue, Your Honor, is just as I said, both parties have paid or filed their taxes separately for 2023 and 2024. The request on that it's a little confusing the way that the tax language in the spreadsheets came out. My proposal is just to remove the tax language for those two dates since they've already filed. The alternative would be to just say that the parties, to put language in basically saying that the parties have both filed separately for 23 and 24 and that they will both be responsible for their own tax debt and their own refunds, as opposed to, because I think the way that they have it set is Mr. Linton would pay 100% for 1 year, but the parties would split 50-50 the other year. And so I think just to avoid confusion, I think everybody just needs to be on the hook for their own tax liability. So that's what we're trying to achieve here.
I don't have any objection to what Mr. Culp is suggesting.
Yeah, especially because I've dealt with at least his tax debt for 24. We're going to see if we can come up with something about her tax debt for 24 to substantiate it.
Okay, thank you. And then our last issue is just there's some waiver of de novo appeal language in here. I just found
I took that. Yeah, that was fine. I didn't catch that. Sorry.
So I'll go ahead and remove that. Oops. If I could have just one brief moment, Your Honor.
Okay.
Okay, Your Honor, I do not have any other issues on the decree today.
I realize that I started before y'all at 1:30. It's now, I've gone more than 2 hours with Miss Primo. I need to give her a break. In the meantime, Miss Mccliment and Mr. Linton, you'll talk about
Piano.
the piano. And then if I need to hear from the parties, when I come back, I'll do that. But I'm gonna take it's 3:49. Let's be on break until 4 o'clock. Okay,
Thank you, Your Honor.
Understood.
thank you. All right. So I've got left to consider the request for SPO instead of the expanded standard and 6 p.m. or school to school at holidays. All right. Anything else? That those are well, y'all, were you able to talk, Ms. Mccliment, where are we on the piano and where are we about the evidence about the tax return?
The piano was something that was purchased during the marriage. It was not a gift to Miss Linton. It was purchased so that the children could have lessons. Mr. Linton's position is that he has asked for several other pieces of furniture in her possession. She's not returned any of them, that she was given an opportunity during temporary orders to move out of the marital residence and take what she wanted. The piano was left behind, and it's his position that he should have the right to keep it since the children live primarily with him. And the piano was procured by both of them and purchased during the marriage for the children's benefit.
What about the tax return, Mr. Culp?
Yeah, I'm gonna have to get her the actual tax return. I think the court gave us a little bit of time on that, but I'm gonna have to get the tax return that the accountant has or is working on. I will be in touch with that person as soon as I possibly can be.
I mean, I'm gonna give you a couple of days. This decree is late. If you can't get it, today's Monday, by Wednesday at 5, then the answer is no, and we don't put that amount on there.
I
In-
understand.
Your Honor, I spoke too soon earlier. In your order, you had stated that for 2023 and prior years that the parties were 50-50 liable and would get 50-50 on any refunds. We would ask that that remain the order of the court and that we not separate the liability. The reason being is that Mr. Linton had $91,000 of tax liability in 2023 because he was ordered to liquidate his retirement in order to give Miss Linton interim attorney's fees. And he had only withheld 30,000 related to his income. So $166,000 is shown as income in 2023 on Mr. Linton's separate return. And because of that 166,000, he had an additional $61,000 of tax liability that he had to pay. And so we would ask that the parties that it remain as the court ordered.
Well, Your Honor, Miss Linton also had to liquidate. I believe it was very close to $100,000 of her own 401k in order to pay legal expenses before the interim, the last major interim fees order in the case, which was, I think, back in January of this year, is when that was either December of last year or January of this year, I think. And so I think both parties had to liquidate their own retirement accounts to fund that litigation, and so that's why we're asking for that just to. And again, they filed separately, so.
Well, not by choice.
Hold on. Let me make sure I'm following you. Were we talking earlier about Miss Linton claiming she has something less than $18,000 in tax liability for 24, right?
2024, yes, ma'am.
They filed separately for 2023.
Correct.
Yes, because Miss Linton wouldn't agree to file jointly. And
that's why on my ruling, it was.
And the tax returns aren't done correctly anyway, because under the law, it's a community property state. Half of Mr. Linton's income should have been filed on Miss Linton's 2023 separate tax return because it's a community property state. And she didn't do that. So I would like it to be 50-50 liability on both ways.
As I understand
Yeah.
that, Your Honor, is that that is a technical rule,
Yes.
but the CPAs that I've spoken with have said that that's hardly ever enforced, if it ever has been. And
But it is the law. I understand that. Most people can follow. It is the law.
well, I get that. I understand, and I'm not trying to.
I don't
just
think the
if
court
we're going to go
can.
back through and scrutinize everybody's tax returns after this has already been after the court's already divided everything up. I mean, we're talking about a $10,000 swing here.
Well, here, hold on. Has his 2023 taxes been paid?
They have been
Yes or
paid.
no?
Yes.
That's why I did it the way I did it. They were paid. There was less community estate. So essentially, she paid part of it already because otherwise there would be more money in the community estate. Yes or no?
That's correct. That's why I put it on my spreadsheet the way that I did, Judge, and I didn't put it as a debt because it had already been paid out of community funds. But my point is, I don't think the court can change what Mr. Culp was asking me to do is to have us not follow federal law, and I don't think that we can agree to do that in the decree. So I would ask that for prior years that it's just split 50-50 between the two parties and we leave it at that.
But they both already filed separate 23 and 24 returns. Yes or no, Ms. Mccliment?
That is correct.
And they
can
both already did it the wrong way. Yes or no, Ms. Mccliment?
Correct. But if the federal government comes back to address
If
that,
they, well, surely if somebody turns them in, you're right about that. If the federal government brings it in, but y'all have now made this so much more complicated than it was when I tried this case for 4 days in June. And I apologize if my fuse is a little short. I've had a really rough couple of weeks. But I'm looking at my spreadsheet. His 2023, I'm not going to change my orders. The only thing I might consider if Mr. Culp can by Wednesday, because I put his tax liability, I put his liability for 2024 on there. If she can get something that substantiates what hers is, I may consider that. I'm not going to go back and redo 2023. I guess that argument should have been made at the time of trial that they filed wrong. And I mean, I can't order them how to file their taxes anyway, as we all know. That's a federal matter. And yes, Ms. Mccliment, I think you are correct that as a technical matter, that's, everybody should report half the income and half the liability. But they chose to file separately. They didn't choose from all the times they were in court to come back to court to say, this is how we're going to do 23 or 4, ask a judge to make an order that she report half the income. So I'm not going to make that change.
I would just ask the court to consider that she could have chose to withhold tax when she got that distribution from the retirement and she chose not to. And now my client's going to have to come up with the money to cover that.
Hold on. That I don't know if it's from the distribution or I don't know if it's from her income that she didn't withhold the money. I have no idea. There has not been any good evidence. I'm giving her a little bit of time. That should have been presented at the time of trial. I mean, maybe the evidence was, and forgive me if I don't remember because I slept and tried about 35 cases since then, but I don't know what it's from. But what does he have the big tax bill for? Huh?
From selling all of the stock to give her money for attorney's fees.
Okay. And it maybe she sold hers to get money for attorney's fees. So why aren't those two things the same?
Well, he did withhold though when he was getting distributions so that their tax liability wouldn't be as great. And that was just my point, is that now he's having to pay more because she chose not to withhold at the time.
In the grander scheme of this estate and how big it is and how much money we've spent on various things, first of all, I don't have any good evidence. I've given her a very short time frame to show you, and you can bring it back to me and then I'll decide, but I'm not going to decide that today. All right, what else? We need to hear from the parties.
Do you want me to proceed first, Judge, with calling my client? Or do
Sure.
you want, okay.
Mr. Linton, would you please unmute yourself and raise your right hand to be sworn? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may proceed.
All right, Mr. Linton, would you state your name for the record?
David Elliott Linton.
Okay, Mr. Linton, since the court made its ruling in June of this year, how would you describe the electronic communications with the children while they were in possession of Miss Linton?
All electronic communications have been very challenging the last 3 months.
Have you communicated desires to speak with the children
Oh,
while
yes. Yes, and I've not been able to have regular communication with the children while the children were in Ms. Linton's possession.
has Miss Linton accused you of not making the children electronically available to her?
She has.
Okay, and is that accurate?
No.
And Your Honor, may I share screen with the
Yes.
court? Okay. And Mr. Linton, can you see Our Family Wizard communication pulled up?
Yes, I can.
And this has been pre-marked as petitioner 7. Did my office export the OFWs between you and Miss Linton since the trial in May?
Yes.
And is this 300-page document a true and accurate copy of the communications between the two of you since that time?
I believe so, yes.
Okay. Your Honor, I'd ask that petitioner 7 be admitted.
No objection.
I'm sorry, is it admitted, Your Honor? I didn't hear.
Yes, I'm sorry. It's admitted.
Okay, thank you. Now, Mr. Lynn, just yesterday, can you explain what happened to the court and what you were attaching to your communication?
Um, it- I had been accused of earlier in the communication of not making the children available for phone calls. That's the opposite of the reality. And I just responded that Ms. Linton does not accept incoming phone calls on a regular basis. So I don't know what to do. And I included the attachment, the picture from earlier that day, or earlier that evening when we tried twice to call Ms. Linton with the children.
Okay, so just so it's clear, you're helping the children facilitate calls. They're not
Yeah.
being accepted. And then Miss Linton in response is sending communications saying you're not making the children available. Is that right?
That is right.
And does
Yes.
OFW log all of that type of activity?
It does.
Okay. And in regards to summer plans, did you reach out to Miss Linton to know if she was traveling with the children?
Yes, I did.
And how would you describe her willingness to tell you where they were?
She did not. She just said she'll reach out in case of emergency.
Right, I'm showing page 223. Is that communication you just referenced?
Yes. Yes, it is.
Okay. And when you're asking Miss Linton to speak with the children, how many days does Miss Linton typically go before reviewing or responding to your questions?
It varies. I think the average is around 2 weeks, but it could be 1 to 3 weeks.
Okay. And let's see. Did you ask Miss Linton if she wanted to have additional time with the children at the beginning of the summer, immediately following the court's ruling?
Yes.
And what were the terms of her willingness to have additional time with the children?
So originally, slightly prior to this, the portion of the conversation you're showing, I asked Miss Linton if she cared to watch the kids for 4 hours on one of other 2 days, and she agreed to a day. And then a couple of hours before the agreed upon time, I think I was dropping the children off between noon and 1. I received this note saying that she wanted $320 in cash and another $1,000 using OFW Pay. And she seemed to suggest that if I didn't do this, that she was going to involve the children. And I didn't know what to do.
The court has ordered that you both have electronic communication with the children every 48 hours. Uh, how long did you go without talking to the children this summer?
There was probably a 2.5 week stretch when I did not speak with the children,
Okay, and
and they
then
were in. Yep.
can you explain to the court what happened at the Camp Longhorn pickup?
Yeah. Yeah. So, by way of quick background, Ms. Linton set the summer schedule all the way through August, or the beginning of school. I had informed her at the time that I wasn't comfortable with the end of the schedule because it was unclear who would pick up the children, and I would not have much time with the children before school started. Oh, yep, that's it. It's where um but I agreed to follow it because I thought that we were going to finalize all the terms by middle of July. When that didn't happen, I still did my best to stick to the summer schedule that Ms. Linton had provided. And in the schedule, it showed change of possession at 8 a.m. on, I think it was a Saturday or Sunday, I believe Saturday. And the cars are supposed to queue starting at 6, and the gates open between 8 and 8:30. And following the schedule, I wouldn't have the children until right before school started. And I tried communicating with Miss Linton beforehand about picking up the children's items. I reached out to Miss Nixon to see if there was a way that we could work together to figure out this possession change. And I was unable to. Ms. Linton didn't respond to my notes until after the pickup. When I
Right.
arrived at the yeah.
So just to be clear, so the court on the second page of its ruling had instructed Miss Linton to resubmit her summer dates, right?
That is correct.
And she did not do that, did she?
She did not.
Okay, so you were left with the possession schedule that Miss Linton had dictated prior to the final trial, correct?
That is right.
Okay, so you still showed up when Longhorn, the last day when the children were being released, correct?
That is right. Yep.
And did the children have specific things and items from your home that they decided to take with them because you packed all of their summer trunks?
Oh yeah. Uh, Lots of clothing, and they all chose to take their own bedding with them. Each child has 2 sets of sheets, and I had to send the children with 2 sets of sheets. And so all of the bedding that the children would have went with them from my house to their camp.
Okay, and so you went and retrieved the trunks, correct?
That's right.
And you notified Miss Linton that you were going to do that before you appeared, correct?
That's right. Yep.
It wasn't a surprise to her, right?
That's right.
Okay. Did she act surprised in front of the children?
Yeah, she began yelling at me, telling me she took out her phone. She started recording me.
Objection, non-responsive.
Oh, can you please re-ask the question?
I didn't know if I heard a ruling from Judge Mossy. I apologize
I
if it cut
said
out.
overruled.
Okay. So Mr. Linton, how did Miss Linton react when you appeared at Camp Longhorn?
Very hostile, very aggressive. She raised her voice just below the threshold, I think, of yelling. She took out her phone, began recording me, instructing me that I wasn't allowed to be there. The kids weren't allowed to spend time with me because it's her possession.
And you mapped out all of this to Miss Linton 2 days prior to camp ending, right?
That is correct.
But she didn't log in to review this for 2 days until the incident had already occurred, right?
That's right.
Um, are there other issues that have emerged because Miss Linton doesn't check our family wizard consistently?
Oh, yeah, it's very challenging.
And are you asking the courts to modify the standard possession schedule just to the traditional time so that you're not having to navigate exchanges with her more frequently?
Yes,
Okay. And do you think that it's in the best interest of your children that they have less overnight possession with their mother?
yes,
Have you noticed any type of regression with your interactions with the children since they had that extended time with their mom over the
yes,
summer?
yes.
Your Honor, I'll pass the witness.
Mr. Culp.
Mr. Linton, you said that you think it would be better to minimize exchanges between you and Miss Linton, correct? That was what you just testified?
Um, I believe I said that, yes. Yes,
Okay. So your request that there be a standard, I guess, a non-expanded standard possession schedule would have you and Miss Linton exchanging the children twice on Thursdays of every week during the school year, and on Friday at 6 p.m. and Sunday on 6 p.m. at 6 p.m. on the first, third, and fifth weekends of every month, correct?
that's right.
Okay, so that would obviously be more exchanges that you believe would not be in the children's best interest to have to go through, correct?
Um,
You agree with me that it would be better, as you just testified, that less exchanges with you and Miss Linton would be better for the
yeah,
children, correct?
yeah. May I clarify my prior read?
No, just yes or no, Mr. Linton.
Okay, then yes, fewer exchanges are better.
And while the children were on their summer trip with Miss Linton, you did have phone calls with them, correct? Or some sort of electronic communication with them, correct?
While they were in California, I did not have any communication with them. No,
While and what dates were they in California?
I'm not sure.
Okay. Um, and so did Miss Linton did not try to FaceTime call you during that time period
No,
or initiate
zero.
FaceTime calls?
No.
Did you try to call her or FaceTime her?
Yes.
Okay. Um, with the Camp Longhorn thing, under the schedule or under the modified schedule that you and Miss Linton had been working off of, or what your assumption was, um, it was your understanding that Miss Linton was going to take the children from Camp Longhorn and take them back to her house when Camp Longhorn concluded, correct?
Yes.
Okay, all right. And so you could have just allowed, and how long after the Camp Longhorn was going to end was Miss Linton going to have possession of the children before it was your time again?
I'm sorry. Can you ask that again? Can you
How
can you
long?
restate
Yeah.
that?
I'm sorry. After Camp Longhorn ended, how long was it until your period of your next? How long between the end of Camp Longhorn was it to your next period of possession?
I believe it was maybe 3 days,
Okay.
4 days.
Um, and where did you guys exchange the kids after that period? Was that at school?
I picked the children up from Ms. Linton's residence.
Okay. And so you could have picked up the children and their luggage from Miss Linton at her residence when you picked them up after Camp Longhorn, right?
Suppose I could have, yes.
Okay. You're planning to continue to work with Miss Rothfuss on these issues that you're having with the children?
Yes, as long as she thinks it's appropriate.
Right. And you think that Miss Rothfuss is helps you work through these issues with the kids, correct?
Yes,
Okay. You've put a lot of faith in Miss Rothfuss's recommendations and her therapeutic strategies for you
yes.
and the kids. Okay. Pass a witness.
Mr. Linton, can you clarify what you believe would be in the best interest of your children as it relates to exchanges with Miss Linton?
Right. I, when thinking of exchanges, there's exchanging the children, and then there's also exchanging items that are in their possession. Both of which instances cause conflict and are difficult. When the children are with Ms. Linton for extended periods of time, that necessitates more exchanges of items, blankets, clothes, things like that. All of these are problematic. And so the fewer overnight visits, the fewer exchanges as it relates to other items. And so I don't want exchanges to be hard, but they are.
Nothing further. Pass the witness.
There's nothing in the order that about Camp Longhorn going forward beyond summer of 2025, correct, Mr. Linton?
That's right.
Nothing further, Your Honor.
All right, Mr. Culp, do you want to call your client? You're not required to, but given that I let Ms. Mccliment call Mr. Linton, I'll allow you to call Miss Linton.
Sure. Ms. Linton, if you could unmute yourself.
Swear you in, Miss Linton. Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Linton, you heard Mr. Linton testify that you did not make any attempts to contact him or facilitate communication between you and the kids while they were in your possession over the summer.
I did hear that, yes.
Is that accurate?
It is in that.
Okay. Did you attempt to, how did you attempt to facilitate communication between Mr. Linton and the children while you were on summer vacation?
Sure. So I tried to follow the order by the T, and the order said FaceTime. So I did not use OFW because the order said FaceTime. And when I was not on data, I would call.
And when you say the order, are you referring to the draft orders that had been exchanged?
I didn't have a draft order, but the letter of ruling.
Okay. So you were, okay. And so relying on the letter ruling, you attempted to make FaceTime calls is what you're saying.
It wasn't clear. I believe the letter ruling said visits over 48 hours, the parent in possession needed to facilitate electronic communication or something to that effect. So it didn't specify if it was once every 48-hour period or just once period for any possession period greater than 48 hours. So I took the more conservative approach and had them contact him at least once every 48-hour period.
Okay, and how did you facilitate that or attempt to?
Sure. So a lot of times I was use my phone, and if we had data, I would use FaceTime, and I would hand the phone to the kids and make sure that they connected. And then when they were finished, I would have them pass to a sibling and then pass to the other sibling, and then they would bring it back to me whenever they were finished.
Did you at any point instruct the children not to disclose their location to their father on your summer vacation?
I did not.
Okay.
I'm sorry, this is a court reporter. I completely missed that question and answer.
Oh,
It froze on my end. If you don't mind just repeating that one.
sure. Ms. Linton, at any point during your summer vacation or after, did you instruct the children to not communicate with their father about where they were during your summer period of possession?
I didn't.
You did not? Is that what you said? You got muffled for me.
Correct.
Okay, thank you. Pass the witness.
Ms. Mccliment.
Miss Linton, did you exercise your summer possession in more than 2 increments this past summer?
My summer possession was exercised in 2 increments. However, the portion exercised between Camp Longhorn and when school started was part of a trade that Mr. Linton and I had made from when he took the kids out of state to Pennsylvania in May. So that was a separate swap that we had made prior to trial.
Right, so for you to agree for him to have possession of the children, to take them to a family member's bar mitzvah, you wanted to have the children when school would resume, correct, on August 12th?
No,
Well, August 9th through August 12th is when you asked to have possession of them pursuant to that swap, correct?
those dates are correct, yes.
Okay,
That's not when school resumes.
but your possession time was not just 2 increments, correct? You selected 3 separate summer periods, right?
Which time are you speaking of? Because I
Well,
had to redo the schedule following the trial, so I just want to make sure I understand your question.
right, following the trial on June 4th, you selected June 16th through July 2nd, July 15th through July 22nd,
Mhm.
and July 27th through August 2nd while the kids were at camp, right, for 7 days during camp time. And then you had that August 9th through August 12th, correct?
I have to look at the calendar.
Okay. Why did you not agree to Mr. Linton coming to Camp Longhorn in order to retrieve the children's property?
Well, the order had stated that a parent was enjoined from attending any of the kids' extracurriculars when they were on the other parent's time. So Camp Longhorn, the gates open at 8 o'clock, which is when my possession time started. So following the order, he wouldn't be able to be at Longhorn for that, and we had discussed that when we made the swap back in May.
But Camp Longhorn is the end of his possession period, correct? His possession period would have ended August 9th, is that right?
It ended at 8 a.m. that morning, and mine began at 8 a.m.
Okay, is that the day of pickup?
It is.
Okay, so the same day as pickup at 8 a.m. when parents are allowed in the gates, correct? Mr. Linton was present to take possession of the trunks, is that right?
I don't know where he was.
Did you see him?
I did.
Okay. And camp was dismissed at that point, right? It was no longer an extracurricular activity for them.
Sorry, I don't understand your question.
Well, you're saying that because it was an extracurricular activity, he wasn't supposed to be present, right? Is that your position?
So the camp gates open at 8 o'clock, but there are scheduled activities at camp until I believe it's 11:30 or 11:45 that morning. So yes, camp is still in session until they close the gates, I think at 11:30 or 11:45.
Do you believe that camp is an extracurricular activity? Is that how you're defining it?
I believe so.
Okay. Did you have the children call Mr. Linton to complain about him having their trunks?
No,
How did you have the children call Mr. Linton when they were in California?
on my phone.
Through our family wizard?
No, because the ruling had stated FaceTime. I specifically did not use OFW to comply with that.
And so is it your position that that you have evidence of FaceTimes occurring between the children and Mr. Linton?
I'd have to dig it up. I'm not handy.
Well, how many times did you have the children call him?
I had them call him at least once for every 48-hour period because I was complying with the ruling.
Were you present or observing the children having those calls?
So I would dial it and make sure it connected. And once they connected, I would hand the phone to the child.
Once the FaceTime connected and you saw Mr. Linton, you would hand the phone to the child?
Yes, or if we were on data and there wasn't FaceTime when the call connected and I saw that there were both parties on the line.
Have you, Did you tell the children or instruct the children not to tell Mr. Linton that they were in California?
I didn't.
Did you tell Mr. Linton before Leah was baptized that you were having her baptized?
No, it was a snap decision on her part. She decided that's something that she wanted to do, and I helped her facilitate that. It wasn't premeditated.
Okay, when did you tell Mr. Linton that she had decided to be
Miss
baptized?
Mccliment,
Mhm.
that, no, I'm not gonna go there.
It's
She
just,
has the ability to do that.
right, but she also has the requirement to share information with the other parent so that he's not maybe caught off guard when the child's saying something to him.
Oh, I mean, there's enough bad behavior to go around, and I'm gonna shut some of this down. I didn't.
I'll pass the witness, Your Honor.
Nothing further, Your Honor.
I'm adding some additional orders. I'm clarifying based on some testimony I just heard. The 48-hour getting in touch with the other parent is by FaceTime or any other electronic means. Ms. Linton, I'm sorry, I don't believe your testimony. And the order will say, and if you don't get the other parent, you must follow up with an OFW message saying what time, when, and how you tried to reach the other parent. And I'm going to include the language, if anybody travels out of state, you must notify the other parent. Based on everything I heard today and everything I heard before, Ms. Linton, I think you intentionally didn't tell him. And if you didn't tell the children directly not to tell him, I believe you certainly gave them that impression. Also, I want to add that both parents are required to give Ms. Nixon releases to speak to any and all professionals treating the parents or the children in this case. And to ensure that my order is being followed, I'm ordering that there be a review hearing with Ms. Nixon present before me from sometime between mid-November and mid-December. And if orders aren't being followed, if somebody has the correct pleadings, I'll be happy to modify them. But I'm going to give people a chance. I don't know. Maybe that's foolish. I'm not ordering the piano. You have until 5 o'clock tomorrow to send me something about the tax return. I'm not going to change the exchange time from holidays. I do think, I thought about this a lot. And Mr. Linton, I hear what you're saying about trying to cut her down on standard possession order to a standard possession order. I think it's going to cause more conflict because I think there will be more conflict if you have more direct exchanges. Any damage she wants to do or continues to do can happen whether she has Sunday night or Thursday night, which is part of why I'm going to have a review hearing. And if things go poorly and there's a proper pleading, I may very well be willing to change the expanded standard to a standard possession. I hope I am heard loud and clear. I expect there to be compliance with this order. I expect there not to be this, the order said FaceTime, so that's how I did it. Be interesting when we have the review hearing, or maybe then Ms. Nixon, that you come up with your phone records to show that there were FaceTime calls placed, Ms. Linton. These children need to be taken out of the middle of this. I'm sure you're unhappy with me and the way this went, Ms. Linton, but your behavior is distressing. All right, anything else I need to, I think I wrote down everything else I needed to rule on. Counsel, did I miss anything?
No, Your Honor.
I have nothing further, Your Honor.
Okay, you've got till 5 o'clock Wednesday to get some documents to me and Ms. Mccliment, and I want a decree entered by Thursday.
Oh,
yeah.
I apologize. Mr. Linton was trying to give Miss Linton $24,000 that she was ordered to have, but she refused to give him wiring instructions so that he could give her that money. Can we just have the decree state that Mr. Linton will remit the funds to Mr. Culp and then he can get them to his client?
Or that Miss Linton can pick them up from your office. If she doesn't want to give wiring instructions, then she has to go travel to get them.
Understood.
Yeah, Mr. Linton can mail them to Mr. Culp if there are not wiring instructions. And then Miss Linton can go get it and go have to cash the check. Anything else?
No, Your Honor, thank you.
No, Your Honor, thank you.
All right, again, by 5 o'clock on Wednesday, I'll make a ruling on that tax issue. That could change some of the numbers. In the meantime, y'all go ahead and get everything but that done, on the decree. So including, and I went pretty fast. Nixon's, the issue about the parent facilitator, I want to add that parents are required to sign releases so that Ms. Nixon can speak to any and all professionals involved in this case. I want to add that I will hold a review hearing between mid-November and mid-December. You two council get together and let me know what date we're going to have that and make sure Ms. Nixon's available. Modify my earlier ruling to require the communication for periods of possession more than 48 hours to be by FaceTime or any other electronic means. And if you're not able to get hold of the other parent, you are required to send an OFW message stating when you tried to call, how you tried to call. And that way, if it's not happening and there's enforcement that has to be brought, there'll be specific language to on which an enforcement could be granted. And there's going to be notice of out-of-state travel. It is reasonable that any parent would know when their children travel out of state. If for no other reason than an emergency, God forbid there was a car wreck or an airplane wreck or something, I'm sure Miss Linton would want to know if Mr. Linton were traveling with the children out of state. It works both ways. Anything
Understood.
else?
No, Your Honor.
No, Your Honor, thank you for the
You,
clarification.
you may be excused.
Thank you.